in the appeal of Kwok against Yao Juan?
Yes, Mr. Chutai.
May it please the Board. A couple of, I take the representation as read. I had three very short points or corrections I wanted to make to my written case. They're somewhat menial in nature, but I might as well give you the correct references. The first is in the first line of paragraph 37 of my written case. I referred to the judgment at first instance, paragraph 33. It should be CAJ rather than simply J.
Just give me one moment. Yes.
First line of paragraph 37 should be CAJ. And a similar correction in the first line of paragraph 39 over the page. And then another slip in paragraph 74.3, where I refer to paragraph 15 of Lao and Chu. It should be paragraph 15 of Ming Siu Hong. Paragraph 74.3.
Sorry, electronic page.
Which is electronic page 7728.
Paragraph 15 of what should it be?
It should be paragraph 15 of Ming Siu Hung, which is the case referred to in the preceding paragraph.
Yes. Yes. Yes.
As the Board knows, Madam Yao's grounds of appeal have been presented under three broad headings, which I propose to adopt for the purposes of my oral submissions. First, as you know, the Court of Appeal's reversal of certain findings of fact by the judge. Second, the Court of Appeal's refusal to admit fresh evidence proposed and relied upon by Madam Yao. And third, the appropriate form of relief in respect of any established unfair prejudice. Starting with the reversal of findings of fact.
Yes, we'd like to be taken quite closely to the evidence, if there is any, on this.
Yes.
I mean, the issue between you seems to be whether there was any evidence or not to support the judge's findings. So we don't mind, as it were, rolling up our sleeves and putting on our wellies and getting it.
Well, I'm very glad to hear that, because I tried to put myself in your shoes, and I thought that probably one useful thing I could do on my feet, as opposed to simply repeat what I've already written, is actually take it to some of the core material.
Yes, please.
Effectively to try to replicate what the judge could be presumed to have seen and heard while sitting through the trial.
And it was seen by read.
Well, read, seen, and heard.
Yes.
All three, presumably. Can I start with the first of the two main factual areas that form the subject of the appeal? The first is the nature and scope of the duty to notify and consult as found by the judge. To understand the context in which the judge proceeded to make that finding, it's important, we say, to understand what Madame Yao's pleaded case was, as well as what evidence she gave. If I can take the pleading very briefly first, electronic bundle, page 292, paragraph 14. You will see it is said, moreover, it was the understanding between Tung Fai, that's the first defendant's husband, and the first defendant on the one hand, and Madame Yao and her husband on the other hand, through numerous discussions between them, etc. And then you can see the three elements of the understanding that were pleaded. And the two that are particularly pertinent, so far as this appeal is concerned, are those in paragraphs 2 and 3. And you will see in 2, there is the plea of notification and discussion, if I can call that the consultation element. And the second, the prohibitive element, which is in paragraph 3 over the page, not to make any major decision or enter into any major transaction and or dealing etc. And then with the words at the end, without the consent of the claimant. Now, I just ask you to note, as a matter of analysis for a moment, because this is a point that I think Mr. Chasty makes in his written case, which is that the judge, in his judgment, and we'll see that in a moment, isn't quite as clear, perhaps, as the pleading is in relation to the question of consent. But imagine for a moment that the words "without the consent of the claimant" did not appear at the end of subparagraph 3. The substance of the agreement would nevertheless be the same as a matter of common sense, because it's essentially alleging that there was an understanding that there would be no major decisions or major transactions taken or entered into of the specified description. By definition, as a matter of logic, that would have meant, even if the words "without the consent of the claimant" had not been spelt out, it would have meant necessarily, as a matter of logic, that Madame Yao was saying she was entitled to be notified, and she was entitled effectively to consent or not consent to decisions or transactions of the specified description. I just ask you to note that for a moment, because there's a slight difference in the formulation when we come to the judgment. In response to that
Well, just before we leave it,
yes.
Is it supported by a statement of truth?
This document is, but in any event, you will see from the relevant witness statements in due course that a similar version or account is set out there. Just for completeness, you will see the response from Madame Kwok in her defense at page 354.
And which page would you like us to?
I'm so sorry. So that identifies the document 366. Forgive me.
Paragraph?
Paragraphs 32 and 33. So if we start at paragraph 32, you will see that there's a denial of paragraph 14 of the re-amended statement of claim, which is the paragraph I showed you a moment ago. And then the substantive plea from Madame Kwok as to what she says the arrangement was at the outset, or the agreement was. And you will see that in paragraph 33 over the page. And in essence, her position is Madame Yao was, what was agreed was that Madame Yao would simply be a financial or commercial investor, but of a passive nature, and playing no part, having no involvement in the management or operation of the hotel in any way.
Was there anything in the amended statement of claim that expanded on what would be a major decision and what wouldn't for the purposes of paragraph 4?
There wasn't a plea about that. But equally, as far as I'm aware, at no point has it been suggested that the groups of transactions that are in issue in this case and that were in issue at first instance and on appeal, that they would not have qualified as major transactions or decisions. So that's the pleading in short. So far as the evidence is concerned, let me start with Madame Yao's own trial composite witness statement, which you will find in the electronic bundle starting at page 635. And I think we can probably pick it up at paragraph 25 on page 635. It's It's where she begins her account of the discussions, the idea of the project, and how the discussions thereafter went. And I think probably the key paragraphs are 25 to 27.
Yes, I can, yeah.
My paragraph 26 hasn't copied, Terry.
Yes, I'm afraid mine too.
I think I can work it out.
Yes.
But if anybody's got one that doesn't have a wrinkle in the page, it would be nice to have.
Well, there is the somewhat ironic help we can get from the fact that Madame Yao's husband's witness statement is in identical terms.
Quite.
And
Without the
his
wrinkle.
doesn't have that quirk.
Big coincidence.
And I will show you that in a moment. We can probably skip over. Well, you may wish to read 20, to glance at 28 and 30 to 33. But the relevant paragraph for present purposes is 34, at the foot of page 636. And in particular, the two elements of notification and not entering into any major decision or transaction without consent. It's paragraph 3. And further elaboration at the bottom of subparagraph 3, just above.
I haven't checked whether it's word for word the same as the pleading, Mr. Troy, but you say it closely follows it.
Completely word for word, but it's not far off, I suspect. I've not actually done a direct comparison, but there are some slight differences. But,
so the agreement, as alleged by Madame Yao, was made by the husbands of Madame Yao and Madame Kwok.
correct, but actually explains there was a sort of process of osmosis, as it were, between husband and wife, which led to effectively both sides essentially advancing evidence from both the wife and the husband, identical in nature. I told you that that there was an identical version in Mr. Wei's evidence, and you can find that at page 872. At paragraph 39.
Oh, that's
872.
not in my number.
873.
Picks it up a little bit early.
7.3 to 4.
Oh, I'm so sorry. Yes. Yes, 873, forgive me.
39 is the one that corresponds with paragraph 34 of Madame Yao's.
Correct. And if you're looking for the equivalent to paragraph 26, I believe it's paragraph 32 on page...
that is 872.
872, yes.
Yes.
Madame Yao was challenged in cross-examination on her account. That appears in the transcript of the evidence on the 28th of November, 2017. And one sees that on page 6089.
And she's being cross-examined here by whom?
This is Mr. Chasty's cross-examinations.
Now, this looks like an English conversation, but as I understand it was going through interpreters, is that right?
Yes.
Yeah.
Yes, it was. Yes. Mr. Chase has the enormous advantage that he was there, but that's my understanding too. So it must have been a rather painful process, one can only imagine, with the entirety of
But anyway, the transcript has, as it were, removed the complications associated with it going through.
Indeed. And I'm certainly not aware of any issue, as it were, being taken as regards the accuracy of the translation. So you will see that the exchange between Mr. Chasty and Madam Yao in relation to the critical paragraph for present purposes begins at line 5 on page 6089. And you may wish to glance at that, but the key point essentially that Mr. Chasty was putting to Madam Yao was, well, you've not stated that there was an agreement. What you have stated is what should be done or what would have to be done, and that's not the same thing as an agreement. That was the gist of it. And you will see how Madam Yao responds to that on that page. And
we're over to page.
And it goes over to page.
The witness statements also being were they
Yes.
made in Chinese and then translated?
They were, yes. The hard copies are rather thick documents, precisely for this reason, that each of the 4 witnesses' statements appeared both in English and in Chinese.
But yes, it's difficult to see how a cross-examination in Chinese on these very nuanced differences in language, how that is actually captured in the... It's difficult for us to know whether this nuanced difference that Mr. Chasty was pointing out, that must have existed in the Chinese versions as well, then.
Well, I assume so. It certainly comes across very clearly in the translation. I'm not aware of any suggestion that the nuance was incapable of being replicated through the translation process or through the interpretation process.
I think Madam Yao was rather on to the point, because I see at a couple of pages further on she suggests to Mr. Chasty that he majored not in law but in literature.
She was obviously a thoroughly well-prepared witness. I think there are a number of other exchanges that are rather entertaining, but probably going beyond the task, the immediate task at hand. And you will see that this exchange probably can be taken to go up to, let's say, page 6092, line 6. There is other stuff around it.
And which, from your point of view, is the absolutely
Well,
the whole thing?
This is 6089, line 5 to 6092.
Yeah.
Line 6 is the chunk that I rely on for the proposition that essentially Mr. Chasty challenged her on her critical account, confronted her with a subtle point, which, if correct, might have made a difference to what the substance of her evidence was, which she responded to.
So this was all the cross-examination that there was on that paragraph?
On that particular point, yes.
Right.
Yes.
And is your point that what he seems to be challenging is as to whether there was really an agreement or something less than an agreement, rather than the scope of the kinds of decisions that would have to be consulted on? Is that?
Well, I want to be very clear about what I'm doing at the moment and what this field is about. We're not here to determine whether the witness was telling the truth. That's not the object of the exercise. I am only showing you the evidence in order to try effectively to recreate the court atmosphere, if I can put it that way, as best I can, to show that the judge, when he came to writing his judgment, had been exposed to a significant or relevant amount of evidence in relation to that issue. And that's an important point, because when you read the Court of Appeal judgment, you might be forgiven for thinking that there was only one piece of evidence in the entire case about the alleged agreement, namely the passage that was set out by the judge, in fact, about a different topic in paragraph, I forget, 19, I believe, of the judgment, which the Court of Appeal then replicated in toto in its own judgment, and effectively thereafter proceeded to say, well, how can this evidence support a finding by the judge in paragraph 41 of his judgment that on the facts of this case there was a duty to notify and consult. That's the critical, that really is the nub of it in a way, that the Court of Appeal, very surprisingly in my submission, having taken the view that there wasn't clarity, putting it no higher than that, in paragraph 41 as to exactly what the judge had relied upon in order to arrive at that conclusion, effectively assumed that the only source of evidence in the case was what the judge had set out in extenso in his own judgment, nothing else. There was no attempt whatsoever by the Court of Appeal to investigate the underlying evidence in the form of the witness statements or the transcripts of evidence. So that's the passage in the cross-examination of Madame Yao.
Was anything said about to her husband when he gave evidence, because he was the man who was supposed to have entered into this agreement?
Well, in fact, I haven't been able to find a specific passage where Mr. Chasty challenges him in relation to this particular topic. I may have been remiss in my review of the transcripts, but I haven't been able to find as pertinent a passage as the one I've just showed you.
Because it's a little odd, isn't it? Because Madame Yao wasn't party to the discussions, as I understand it. It was her husband who entered into the arrangements with Madame Kwok. And she's just repeating what her husband has told her or what her understanding is. So I can well understand a cross-examination along the lines of, well, you don't know that there was an agreement.
Yes.
Your understanding was that certain things had to be done, and that falls short of there being an agreement.
Yes.
In that case, I would have expected counsel to have challenged the man who entered into the agreement and put it to him squarely that there was no such agreement.
Yes. Well, as I say, I stand corrected by Mr. Chasty, who will either recollect or will find any relevant passage far more quickly than I've been able to.
Thank you.
So just pausing here, we say therefore that Madame Yao clearly maintained in her oral evidence that what was described in her witness statement was what had been agreed, not merely as something that would be done, but as something that had actually been agreed. The judge would have read her written evidence, and not least because he says in terms, and we'll come to the relevant passage in a moment, that he has taken account of all of the witness statements, and would have seen her give evidence in person when cross-examined.
Well, not only that, Mr. Choi, but he specifically took account of the fact that the two witness statements were in virtually identical terms, and that the way in which they gave their evidence to the court was slightly different.
Yes. Yes, he
So
says
he's
in
got
terms.
that well in mind.
Absolutely, it's not as if he was oblivious to the whatever lawyering, if I can put it that way, not to imply any impropriety, as it were, but in terms of the very nature of the process. In fact, you may recall that Madame Yao herself addressed that issue and said, well, look, we discussed it with the relevant lawyer, and he drafted it, and effectively we were happy with the substance of it, but it's not surprising from that perspective, and it won't be the first time in English legal history or any country's legal history that two witnesses who attended the same meeting or were part of the same discussions happened to give an identical account of their evidence. The judge, therefore, was well aware of the potential danger of an arguably overly lawyered set of witness statements from two witnesses. But he made the observation that you've just referred to. But it's interesting also to look at what Madame Kwok was cross-examined about, because that case, as set out in the witness statements, was actually put to her too. We see that in
we
the
need to see her witness statement, or are you letting that pass by?
Well, I'm letting her statement pass by because her statement essentially repeats what's in her defense, i.e., from our perspective, this was just a financial investment. They were going to put the money in, leave us to run it, and that's it.
She didn't accept that there was this obligation that the Court of Appeal found of consultation at investor level, as they call it.
No, she didn't accept that either.
She just said we got the money and we could do what we wanted, basically.
Essentially, yes. If you look at the 6th of December transcript at page 6519,
yes, line 8.
Line 8. It was admittedly rather briefer, a cross-examination, but you can see the basic case being put to her. Up to line 25 on the same page, in relation to the relevant part of the agreement we're concerned with. But
She simply expresses disagreement at every
she
step.
says yes.
Well, then it goes on from 17 to 24 on the consent issue.
Sorry, I think I may have the wrong page number. Which page number was it?
6519, my lord.
6519.
Yes.
Yes, I got that.
I'm going by the ED page numbering rather than the
Yes.
competing
Yes.
numbering just above it.
What I've got is all about the loan.
Does your 6519 begin and until she was able?
I don't know what's happened here. I don't know what's going on here. Anyway, give me a moment. Yes, something went wrong then, but I've got it now, thank you.
Thank you. So it's the entire exchange from lines 8 to 25, dealing with both elements of the alleged agreement.
It's a sort of live repetition of the exchange of pleadings.
Yes, in terms of how the question was put.
Yeah.
Yes,
And the joinder of issue.
well, yes, indeed. The disagree was the layman's version of deny.
Yes.
Essentially. So that is the material that I have been able to find in relation to this particular issue.
Thank you.
Of course, there aren't hundreds of pages on it, but there are a number of pages where the issues grappled with. There were obviously lots of other issues in the case as well, and those occupied a large amount of time too. But for
present purposes, the key point, we say, is that the judge at the trial would have seen, read and heard this material. And it's important to bear that in mind when we come to the judgment itself, which I now propose to do, which you will find in the key documents bundle at tab 5. Forgive me, tab 5. If I start with,
so there was no discussion about in the evidence about what kinds of decisions, how could it make sense that she wouldn't be consulted, no sort of
there was no exploration
of the commerciality of the arrangement on either case.
As far as I've been able to find, the cross-examination was conducted quite succinctly, if I can put it that way. Perhaps that was a reflection of the very large number of other issues involved in the case. And again, I'm not saying this because that is intended or should be treated by the board as degrading, as it were, the quality or the importance of the material I've just shown you. But I can quite understand how, in a trial involving foreign language witnesses, the full armory of an English-speaking advocate may be rather more difficult to deploy, and one may have to cut one's cloth accordingly. But that being said, it can't be, of course, and it's not suggested anywhere in the authorities, that the principles relating to circumstances in which an appellate court can review findings of fact should, as it were, materially vary, depending upon whether or not the testimony has been conducted in English as opposed to foreign language. Certainly not in a situation where, as far as one can see from the evidence, there's no reason to suppose that the basic process of question and answer and challenge and response that one would normally have in an interrogation or a cross-examination process could not have been effectively conducted, even if somewhat shorter, than might have been the position if it had all been in English.
But if one's going to accept one account rather than the other, and all one can see in the cross-examination is a series of questions in which extracts from the witness statements are put to the witness, and insofar as they reflect the evidence given by the other side, the witness simply says disagree. Yes. One might hope to see a little bit of reasoning by the judge as to as to how the judge justifies the conclusion to which he's come.
Well, you say that, but it cuts both ways, in fact, doesn't it? Because one could take the view that when the cross-examination that's been conducted of a live witness is very brief, it may be much more difficult for a judge to give extensive reasoning as to why he or she prefers one witness's version as opposed to another. It may simply be that the assessment of credibility and whatever one can glean from seeing the relevant individual in the box, speaking in a different language, interacting with the interpreter possibly for an extended period, that all that you can glean from that is essentially very intangible, very subjective, and not necessarily susceptible to being explained very extensively. And the difficulty, of course, always is if you have a straightforward conflict of evidence as to what was agreed on a particular day at a particular time between two people, and there's no documents at all that throw light on it. How far can you go, even if they're all speaking beautiful English? How far can you go in terms of saying, well, I believe that one rather than the other one?
One might say that to reach an agreement in accordance with the account of one side rather than the other would be an extraordinary thing to do in the light of the commercial experience and circumstances of the particular transaction.
That's one possibility, absolutely. But another possibility would simply be that looking at the body language, the demeanour of one witness compared to the other, you consider one of them to be more credible than the other.
That is more difficult if the witnesses are giving their evidence in a foreign language and from a different cultural background. There's very little you can reliably read into things like body language and so on, isn't there?
Well, I'm not sure that I would be as bold as that. I can see,
Yeah.
I can certainly see that. Of course, I'm being slightly facetious now, but I was thinking of saying, well, it may rather depend on possibly on the nationality of the witness in terms of how body language may or may not be pregnant with.
You might be looking perhaps for something a little bit less ephemeral, like inconsistencies in other parts of the evidence. You might be looking at the evidence as a whole and saying,
Yes.
this part, there was inconsistencies there which go to the weight that I put on this witness's evidence.
Yes, I accept that. One can see how, if there are lots of issues, then one's view as to a witness's credibility on certain other issues, which may have been potentially aided by documents, might then lead to the conclusion that one witness is more credible than the other. There was an element of that going on in the judgment, because you may recall that the judge, I'm not suggesting that the judge positively relied on that as to why he preferred Madame Yao's evidence in relation to the notification and consultation agreement. But he did give a couple of examples of how he found that Madame Kwok had not given credible evidence, and you see that in paragraph 33 and 34 of the judgment.
In his descriptions of the witnesses and his assessment of them was actually quite lengthy compared to the shortness of the rest of his
Relatively speaking, of course. It's all relative, but yes, absolutely.
Yes.
He gave quite a relatively lengthy description of how the impressions he had from their giving evidence, from paragraph 29 onwards, and then he pointed out in paragraph 34.
Can you just locate me back on an electronic page, please?
Oh, I'm so sorry, my lord. Yes, of course.
On 63.
Thank you. I'm not using a core bundle.
Yes.
I've got it.
Thank you. But I'll come to those paragraphs in a moment, if I may. But let me just go back to the beginning of the judgment. So if we look at paragraph 6, which is electronic page 151, you will see that he sets out what the claimant's case was. So he was very clearly aware of both the pleaded case and the evidence, and he actually sets out the alleged agreement with the two relevant elements for present purposes of subparagraphs 2 and 3. You will note, however, he did not repeat the words at the end of subparagraph 3 without Madame Yao's consent. But for the reasons I gave earlier, as a matter of logic, that doesn't really make any difference to the analysis. And the real point here is that he appreciated fully what the case was and what the evidence was. And then if you go to paragraph 7, he faithfully reproduced what Madame Kwok's essential defense was, including in the last two lines of paragraph 7 on page 151, that both Mr. Wei's and the claimant's involvement, according to Madame Kwok and her husband, would never be more than as passive investors. and that it was never intended that the claimant would become involved in the management of the company.
Mr. Chasty seems to have had some success in demonstrating Madame Yao's lack of experience.
Yes, in the actual management and operation of hotels, and obviously the judge was aware of that and appears to have taken account of that too. If you then go to paragraph 13, he makes the point that they clearly reached some agreement as to their participation in the construction and operation of the project. And then if you go to paragraph 16, page 154, you can see a description of Madame Yao's case at paragraph 16. And if you look in particular at subparagraph 2, you will see effectively a blend of the case based on both notification and the obtaining of consent in relation to major decisions or transactions. If you then look over the page, just below subparagraph 4, he says all of the above, she claims, were in breach of an agreement or understanding between them, which came into being before or at about the time that they became 50-50 shareholders in Crown Treasure. So effectively a basic summary, a basic but important summary of the pleaded and evidential case. And then if you go to paragraph 19, he deals with one particular topic which appears under the heading "the permitted investors." So paragraph 19 starts on page 156. He sets out an exchange in relation to the question of who might be permitted to, who else might be permitted to invest into the project and the types of funding that might be contributed to the project. There is that exchange which the Court of Appeal heavily relied upon. You will note that the heading there was not generally, or the subject matter was not generally about effectively any or all major transactions or decisions. It was about permitted investors and funding.
Do you have a bundle reference for where that evidence is in the transcripts?
Do you mean the evidence is referred to at the beginning of paragraph 19?
Yes.
I believe that at least the part that's dated 6th of December is the passage that I showed you. At least in part, I think. But I don't have to hand, I'm afraid, the precise passages that Mr. Fisher had relied on in relation to that issue. It may be that I will find that.
I think it might be useful for us to be able to look at the context in which that evidence was given.
Yes.
Don't do it now, but if you
I'll come back to you on that if I may. But I agree, I can see that it's important for context. And I could well be wrong that it may not necessarily have coincided with the passage that I showed you, because there were effectively the cross-examiner was going through the menu, as it were, of things to put to the witness, and it may have been on the same day, but it may not have been necessarily in the same passage or on the same page. If you then go to paragraph 35. Well, you may recall, so paragraph, forgive me, if we go to paragraph 29 first, just to tick that off. 29, page 162, 29, 30, all the way to 33, is, as Lady Rose pointed out earlier, is somewhat lengthier description of the witnesses and how he found them. And two of the examples that I said where he thought that Madam Kwok had not been entirely truthful are given in paragraph 33 and then paragraph 34. He made the comment in 34, these are two examples which led the court to the view that although she was basically an honest witness, the objective of proving her case could easily compete with telling the complete truth. So here again, the court had to weigh her evidence against the objective facts and surrounding circumstances as came out in the evidence. And then 35, no contemporaneous documents were presented that record or evidence any agreement reached between the parties in relation to the management, financing and operation of the hotel. It therefore fell to the court to evaluate the evidence of the witnesses at the trial and to make a determination as to whether such an agreement was made and what were its terms. So he's clearly grappling with the issue, or at least identifying the critical issue he has to deal with and resolve. He didn't misdirect himself in any way as to that, and he was entirely right to say that it all came down to his evaluation of the witnesses. And he expanded on that a little at paragraph 36 by saying, I shall in each case briefly set out the areas of complaint and the views of the parties as disclosed in their pleadings, witness statements, submissions and oral evidence, and close with brief findings of fact. My findings of fact also took into account the latter matters as well as what I gleaned from the demeanour of the witnesses. If you then go to 38, you will see that he records that the claimant says that the defendant withheld from her information that she should have been given and which, had she been provided with it in advance of various transactions instead of months and years afterwards, might have averted the breakdown in relations that has led to these proceedings. And you can see in letters A to C the key transactions that form the subject of the trial. If you then go forward to paragraph 41, the requirement to give information is not circumscribed solely by the Articles of Association of the company. There are other factors to be considered, such as the initial arrangement between the parties, whether in any case the information ought to have been given, or the claimant ought to have been consulted, would depend on the nature of the action proposed and the terms of the arrangements to be made. And then the critical words that were the subject of close analysis in the Court of Appeal on the facts of this case, there was a duty both to notify and consult. Now, I just want to unpack this a little because I think there is far more to be understood and gleaned from paragraph 41 than is apparent from the Court of Appeal's judgment. The judge is saying that the requirement to give information is not limited to what's set out in the Articles of Association. There are other factors to be considered. First, he identified the initial arrangement between the parties. So he's obviously alive to the importance of any informal, unwritten agreement or understanding between the parties at the outset of their relationship. Two, the nature of the action proposed. And three, the terms of arrangements to be made. In other words, he's contemplating the possibility that there may be further terms agreed that may alter the initial arrangements. And then the language of whether in any case the information ought to have been given and or the claimant ought to have been consulted, all of that, in my respectful submission, the entirety of this paragraph, leaving aside the last sentence, the entirety of this paragraph is effectively language echoing the agreement alleged by Madame Yao, that her case was, her evidence was, that there was an agreement for notification and consultation and the seeking of prior consent in relation to major actions. Because it's very difficult otherwise to understand why the judge is saying the requirement to provide information should depend upon the nature of the action proposed.
You can put it another way, which is that what he's not saying is that there was no requirement to provide any information at all, which was Madame Kwok's case.
And he's not saying either that there is a requirement to provide information about everything that goes on within the company. He's saying neither. But I agree, against myself, if I can put it that way, I agree, I accept the judge's final sentence in paragraph 41, if read in isolation, does give rise to some uncertainty as to which facts of the case he is relying on, and as to the precise scope of the duty to notify and consult that is found. I accept that.
Is one entitled to do a little bit of archaeology and look at the Articles of Association of the company? And if you don't find it there, then maybe you find it in the arrangements between the parties.
Well, of course. I mean, this is the classic case where...
we know what the articles say.
We all know what the articles say, absolutely.
So nobody's looked at them or asked us to look at them yet, I don't know.
No, but I'm pretty confident there's nothing in there that relates to this particular topic. But the point that I make, just pausing at paragraph 41, is this. And I believe this is a principle that the board will be very well familiar with, which is that an appellate court must not be overzealous in dissecting an isolated paragraph of a trial judge's judgment. Paragraph 41 has to be construed in the context of the judgment as a whole. The earlier parts of the judgment that we've already looked at identified Madame Yao's case and her evidence as to what had been agreed, as to the need, she alleged, for her to be notified and consulted, and for consent to be obtained in relation to major transactions or decisions. If you then read paragraph 41 in the light of what follows paragraph 41, the uncertainty, whatever uncertainty one might have had as to what exactly the judge was saying, rapidly disappears. Because what you find is, and this is admittedly something about the structure of the judgment that I would confess is, in hindsight, perhaps regrettable, which is that having made the comment he made about the duty to notify and consult, what he then goes on to deal with in section B of his judgment is not the subject matter of the duty to notify and consult, but a different topic, which is failure to match funding. But if you make allowance for this structural imperfection in the judgment, if you go to section C, and imagine for a moment that paragraph 41 is to be read as a continuum, followed by an incorporating section C that you find on page 171. What you find is a section that specifically deals with failure to notify the claimant of and to obtain the claimant's prior consent to a number of major decisions, transactions, and other important matters. And there are important passages in that section, quite apart from the heading, which is at least indicative and helpfully so in my submission. if you look in that section where he essentially grapples with the details of the various transactions that form the subject matter of the complaint of unfair prejudice, if you go to paragraph 66, having made the point that that Madame Yao was not consulted in relation to effectively the conversion of her initial contribution into a very long-term loan to 2045, he says in 66, the actual decision per se is not necessarily being criticized. The defendant was allowed to make management decisions. What is being criticized most is that she did not consult and inform the claimant of the planned contract, thereby giving her an opportunity to be heard on it in line with their agreement. Now, the word their agreement, self-evidently, is a reference back to what the judge had identified as the claimant's case and her evidence in relation to what she said was the agreement. And he then makes the finding in 67, I find that it was a breach of their agreement not to have notified and consulted Madame Yao about the planned arrangement, and it was unfair and prejudicial to her in her capacity as a 50-50 shareholder. Moreover, because of the onerous terms under their particular agreement, she should also have been given an opportunity to be heard on the intended terms, etc. So that's
saying that if given that the context was a choice between no duty to provide information because she was going to be a passive investor, or the duty which Madame Yao was arguing for, which was limited to major decisions, he seems to have firmly found in favour of the second, and nobody was arguing that Madame Yao had to be consulted about every aspect of the hotel business, so he didn't have to deal with how broad the scope of the obligation to notify was.
Correct, which is exactly this third possibility that no one had actually canvassed, as it were, or argued, was exactly what the Court of Appeal found should be the correct interpretation of paragraph 41, because it simply says, on the facts of this case, there was the duty both to notify and consult. But it becomes even clearer, because if there were any remaining doubt after you've read the precursor paragraphs to paragraph 41 and the ones that follow in section C, because if you then go forward to paragraph 75, you will see when dealing with another of those major transactions in section C, he deals with the cooperation agreement between Strong Nation and Sheer Fancy, and at paragraph 75 you'll see what he says there.
But that's relating to the other aspect that he's already dealt with in section B, isn't it? That's dealing with the agreement not to introduce investors.
I think you may well be right about that where he is referring to their agreement here, he is referring to the agreement that he'd found in relation to the subject matter, paragraph 19. But just as a matter, just to dwell on that just very briefly, there's obviously an interrelationship or an overlap between those two aspects, because
it's a major management decision.
It's a major matter, really. If you're going to introduce a third party whose introduction or participation is going to result in a dilution of your shareholding.
Well, it becomes clearer when you look at paragraph 77. I suppose, in fairness.
You're ahead of me. Yeah. If there were any doubt that the judge, having gone from paragraph 67, where he clearly appears to have made a finding of an agreement as alleged by Madame Yao in relation to notification and consultation, and that somehow concluded by the time he got to 75 that there was only one relevant agreement, namely in relation to the introduction of investors, just see what he says also. In relation to the same subject matter, in paragraph 77.
Which again misses out the words without consent, but you say they're in essence implied.
Yes.
Yeah.
Because in fact he's focusing on the prohibition rather than the way out of the prohibition through Madame Yao accepting.
And what is that? I mean, it's in quotes and indented. What is it actually quoting from? Do we know?
Well, I think he's quoting the language of what he says in paragraph 16, where he sets out Madame Yao's case.
Yeah.
So he's effectively saying, I suggest loud and clear, at least in paragraph 77, in my view, I find that the agreement was as alleged by Madame Yao.
I don't think, speaking for myself, I don't think there's any doubt that he's making a finding that the agreement was as per Madame Yao's case. The real question is whether or not he had the material on which to make that finding, or whether he properly explained why he'd made it. Because the Court of Appeal seemed to think that, rightly or wrongly, that the evidence didn't go far enough to enable him to make it.
Yes, and the short answer is, I've shown you the evidence. The Court of Appeal did not refer to that evidence, gave no indication that it even considered it. There's not a hint in the judgment, a very, very long judgment, which spends an enormous amount of time analysing what can or can't be got out of the short exchange set out in paragraph 19 relating to permitted investors and funding. Now, it cannot be on any view that, let's assume for a moment that one is an appellate court, but if an appellate court thinks a judge has got it wrong on the evidence, forget for a moment the higher level principles you've got to bear in mind when it comes to trying to review a trial judge's finding of fact. Let's assume for a moment you're a Court of Appeal judge or an appellate judge, you think there's something wrong here in the trial judge's treatment of the evidence. What you do is you look at the evidence. What you don't do is to assume a fortiori if you think the judgment is defective in some way. What you don't do is assume that the judgment should be treated as the sole source of the evidence, and everything, as it were, has effectively treating the judgment as some kind of bootstrap that has to hoist itself up, or otherwise it's forever doomed, essentially. But somewhat amazingly, the Court of Appeal simply doesn't even refer to the evidence, the underlying evidence at all.
And you would say this is a classic case where of 100 points that are dealt with in the course of a long trial,
yes,
one of them or two of them go up on appeal and then are subject to the level of scrutiny that they might not have got at first instance level, but the Court of Appeal should bear that in mind before criticising the judge for not putting in as much detail as it would have been useful.
Yes, and in a way, of course I agree, in an ideal world, in a perfect world, Mr. Justice Adderley would have added a few more paragraphs and put a bit more flesh in the judgment. I agree. And then we wouldn't be here, or we wouldn't be having this argument. I agree. But that's not the question. The question is not whether the judge has delivered a perfectly balanced and sufficiently comprehensive judgment. The test is whether, having seen what he would have seen, whether it is possible to say that the conclusion that he arrived at is simply something that no reasonable trial judge could have arrived at, and that none of the advantages that he had as the trial judge can explain why he arrived at the conclusion that he did. When you put it that way, it's just impossible to reach the conclusion that either the Court of Appeal or this board can do better. Just take, for example, your very valid point about the difficulties of translation. Let's take that for granted. Does that mean that an appellate court, because there was a process of translation, therefore is in a better position than the judge to weigh, two directly conflicting accounts as to what was agreed on a particular day? It's very difficult to see how a court of appeal can say, well, we are in a better position, because it's not about construing a document. It's not about pure logic and trying to find flaws, particularly when the trial advocates themselves have not embarked on that exercise. How can a court of appeal even begin to imagine or hypothesize in that way? So, granted, therefore, the trial judge's task may have been more difficult than it would have been, or might have been, if all of the evidence had been in English. That still doesn't take away all of the advantages, relatively speaking, that a trial judge has over the appellate court. And to that extent, therefore, all of the principles that we've set out in our written case in relation to the warnings against undue appellate activism continue to apply, in my respectful submission.
One of the ironies in this case is that the Court of Appeal deliberately didn't interfere with other fact findings in relation to adverse findings against Madam Kwok.
Indeed.
So it appears to have been operating, to use neutral language, on an apprehension that the judge's findings in relation to this critical issue of what was decided stemmed from the passage in cross-examination that was quoted in Section B.
Yes. It's almost as if it's almost as if they approached this as a matter of construction.
Yes.
This is the finding or the result that is being contended for, and what we have to construe is that passage, and all three of them thought, well, it's not possible to get out of that passage this finding of fact, which is a bizarre, with all due respect, a bizarre way of approaching it.
It did go a bit further than that, didn't it? Because I think they recall that they asked Mr. Fisher to point to the evidence which supported the judge's finding, and they recalled that he was unable to do so.
Yes. Well, it may be that was one of the reasons why it ended up in that way.
Their decision. It may be a wrong basis, but that there wasn't evidence to support that finding, and that the judge had somehow inferred the agreement as to requiring consent to major business transactions from the nature of the relationship, rather than as a matter of express agreement, because they were not taken, it appears, to any evidence which established that there was an express agreement.
Yes.
Now, I mean, that would, if the Court of Appeal were right about that, that would be a perfectly proper basis for their decision. And if there isn't evidence of an express agreement, well, then you can't establish the express agreement. So it all comes back to, well, what was the evidence?
Yes. Yes, it does, and I accept that, and I agree. I would have, if the position was that there was no underlying evidence, there hadn't been any oral evidence, there hadn't been any cross-examination about it, and if the judge himself had not identified what Madame Yao's case was and what her evidence was as to what had been agreed, and all that one had was paragraph 19 and a general description of the relationship as that of an investor, I can see that the approach of simply looking at the conclusion in paragraph 41 and then trying to work out how one can logically get that out of paragraph 19 would have been a legitimate one. But that's not the position that the Court of Appeal was in. And so we say that having read if the Court of Appeal had read the judgment as a whole and actually tried to understand what the evidence of Madame Yao was, which supported her pleaded case, it's very difficult to see in the light of the passages that we've just looked at, including in particular, for example, paragraph 77 of the judge's judgment. It's very, very difficult to see that they would have felt able to say, well, we, the Court of Appeal, are in a better position to make a different finding about that aspect.
where did the Court of Appeal get this idea that the agreement was limited to major decisions which introduced a new investor? And was that something that had been put as an alternative to there being no duty to consult at all?
Well, as I read their judgment, that as well is based on effectively overworking what could be inferred from paragraph 19 of the judgment. And you see that, one sees that in particular in paragraph 31 and 32.
31 and 32.
And forgive me, of the Court of Appeal's judgment, which you find at pages 222 and 223. And in fact, if you look at paragraph 34 as well, on page 223, you will see Court of Appeal says, in relation to his finding of a duty to notify and consult, it is clear that the judge relied on his own analysis of the exchange between Mr. Fisher and Madam Kwok on the issue of permitted investors and types of funding.
Sorry, which passage are you reading from?
Paragraph 34 on page 223
Yes.
of the Court of Appeal's judgment. This is where they actually set out that exchange. And then in 35 they say, over the page, now the most that can be gleaned from this exchange is that Madam Kwok agreed that the only investors were to be herself and Madam Yao. Funding would be limited to both of them and bank financing, and Madam Kwok could not bring into the project any investor or utilize any non-bank financing without first obtaining Madam Yao's consent. The requirement to notify, consult, and obtain consent was at the investor level.
I see. So they say that the only duty to notify and consult is a sort of ancillary duty, given that it's been agreed that there will be no other investors other than them and banking finance.
Yes. So treating the paragraph 19 exchange as the sole relevant universe of evidence as to what had been agreed in relation to the question of notification and consultation.
I'm not sure that you can even go that. I mean, just thinking aloud, if a witness's case is there was no duty to notify and consult at all, it's a pure passive investment, and then that witness in cross-examination concedes one aspect of a major duty, why can't the judge extrapolate from that concession a wider duty to consult? Because her case has been throughout, there's no duty at all.
Or which I think is the point you're making, or conclude in the light of that the other witness is more credible than that witness.
Yes.
Indeed.
Well, it cuts both ways, doesn't it? Because didn't Madam Yao ditch quite a lot of her case?
I agree. But the judge was aware of that too. It's not as if one could say that he ignored that. And in the same vein, it would be right to point out that he preferred the evidence of Madam Kwok in relation to the so-called Fuji oral agreement concerning how the initial 160 million Hong Kong dollars, whether half of that should be treated as coming from Madam Kwok, as opposed to all of it being treated as coming from Madam Yao. So Madam Yao did not have it all her way in relation to direct conflicts of evidence as to the primary facts relating to what was agreed over a large number of topics. She didn't. But again, this is not an aspect that one could say the judge was unaware of or failed to take into account. So we say there was no justification in the Court of Appeal ignoring the judge's clear summary of Madam Yao's case and her evidence at paragraphs 6 and 16 of his judgment, his explicit statement at paragraphs 35 and 36 that he had taken account of the parties' pleadings, witness statements, and oral evidence, and the demeanour of the witnesses, and his explicit findings at paragraph 77 that, and in fact, I forgot to show you, but I think for completeness, you should also see paragraph 80 of his judgment, where he refers again to something being in breach of their agreement, which again is important for context. So this is page 176.
That is going to the investor aspect of the
agreement. Well, you're right, but it's also related to. This is why, in a way, I recognise when Dame Geraldine Andrews when Dame Geraldine was making the point earlier about funding. There is obviously a certain amount of overlap between those two aspects.
Okay. Yeah. Do we have a transcript of the hearing in the Court of Appeal?
I believe somewhere.
I was just reflecting on the court's observation that counsel couldn't point them to any supportive evidence.
Yes. I think this will be somewhere in the reproduced record. So we'll look that up.
If anybody can pinpoint the passage where that occurred, it would be helpful.
Yes.
Well, is that all you want to say on point one?
Yes.
I take it you don't think you need to rub our noses in the authorities on the extent of the...
No, I don't think that I would have to, not least because they're all authorities of this court, if not of some of the judges on this court. Yes, I think I've probably covered the gist of it, and I'm just looking at my notes to see if there's any little concluding points that I want to emphasise. Yes, in short, if you take all that I've said into account, we say that the board can confidently conclude, as the Court of Appeal should have done, that the judge had accepted Madame Yao's account of what had been agreed, and that it was that finding, the finding of that agreement, that led the judge to state, paragraph 14, that on the facts of this case, as amplified in section C of his judgment, that on those facts there was a duty both to notify and consult with respect to major transactions or decisions. And the agreement was the source of the duty, and the scope of the duty flowed from the terms of the agreement. It's true, the judge did not state in terms, I prefer the evidence of Madame Yao to that of Madame Kwok on the issue of consultation. But he had taken care to describe his assessment of the witnesses at paragraphs 29 to 34, and he had taken care to emphasize the importance of his evaluation of their respective credibility, including through their demeanour. And the choice, we say, for the judge as to who was more credible was eminently one for him as the trial judge, who'd spent the greater part of 24 days hearing and watching the four key witnesses, not just on the key issue of notification, consultation and consent, but also on a number of other topics. And if the Court of Appeal had properly understood the nature of the judge's factual findings, it is impossible to see how it could have concluded that it could properly interfere with those findings consistently with the well-established principles that we've referred to in our written case. And just a final point in relation to this, because I think this is probably the only point where my learned friend's argument about lack of reasons may have some conceivable traction. That's his argument about there are simply not enough reasons. And obviously we've debated to some extent that point already, but the bottom line in my respectful submission is in a case where there are conflicting accounts as to what was orally agreed, there's only so much one can say or do. What you can't say is that the Court of Appeal, just reading the transcript, would have been in a better position and should embark on that process in preference to the trial judge. That can't be right. And in fact, it's fair to say the Court of Appeal didn't say that either. But they conducted a different, but nevertheless flawed exercise. That brings me to the second factual area that I can be very brief on, which is the question of failure to match funding. I've dealt with this in detail at paragraphs 43 to 49 of our written case. There's frankly not much to add, save to point out the overall nature of the Court of Appeal's errors in relation to that aspect. The first fundamental failure, again, was a failure to consider the actual evidence. Here, too, the Court of Appeal proceeded on the basis that the totality of the evidence was essentially paragraph 19, and went on to ignore a whole raft of evidence from the witnesses as to the funding aspect. I quote the relevant references in paragraph 45. Forgive me, I'm jumping around. There is one important point, final important point, that I ask you to bear in mind in relation to the interpretation of the judgment. And this is that the other side themselves, when agreeing the statement of facts and issues with us, agreed what the judge found. And you will see that in paragraph 3.4b, which is electronic bundle page 7667. The trial judge, it starts at 7666. The trial judge, Mr. Justice Adderley, concluded in summary that the agreement was to the effect that A was about funding, and then B, which speaks for itself. It's exactly what he found, and the other side themselves know that, or appreciate that as a matter of analysis. But I'm not trying to sort of rely on any misfortune that the other side may have had in agreeing something they shouldn't have agreed to. This is there's obviously plenty of evidence.
Well, as has been put to you before, that the issue is not what the judge found, but whether there was any evidential basis.
Well, I agree with that too. Yes, yeah. But the point I think that's the point that was put to me by the board. But I don't think that that's that the other side concede that the Court of Appeal was wrong as to what the judge had decided. They rely on the Court of Appeal's judgment. So the only point, therefore, I'm making, I agree it's a limited point, is that when agreeing the statement of facts, they saw the force of the interpretation that I've put to you. But going back to funding, forgive me for interjecting with the first point again. But if you look at paragraph 45 of my written case, so this is page 7709, or tab 3 of the key documents bundle, electronic bundle 7709, you will see a significant number of evidential sources supporting the view that funding was understood by the parties to include either equity injection, if I can put it that way, or loan capital. There was no attempt to separate or differentiate between those two types of contribution. And that was apparent from Madame Kwok's own evidence that we quote, for example, in paragraph 45.3, as well as various passages that were referred to in her cross-examination in paragraph 45.6. I simply haven't got time to take you through all of that, but this is reasonably well researched, I believe, and no doubt Mr. Chasey will pick holes in it, but there was a substantial body of evidence, objectively speaking. But moreover, the judge himself demonstrated in his own judgment, as we set out in paragraph 46, that he had paid attention to at least some of that evidence, key aspects of that evidence, as to why he reached the conclusion that there was an obligation to match funding, including via loans. And we do say in this regard the Court of Appeal essentially failed to have proper regard to the principles against undue activism. The high point of the Court of Appeal's reasoning was the supposed logical flaw of logic that they saw in an agreement that there could be contribution in the form of either equity or loan capital, particularly if the loan capital could be repayable on demand. And the Court of Appeal couldn't quite understand how that would work. But this is the point which, in my respectful submission, is essentially either exaggerated or overworked. And we address that in paragraph 48.3 of our written case, page 7712. There were a number of other points. I mean, if you pick it up on 48.1, I mean, I summarize at 48 the key aspects of the Court of Appeal's judgment. The first point they made was, well, this conclusion doesn't depend on the credibility of witnesses. But as I point out in 48.1, that's only if you ignore what was said by the witnesses in relation to the topic. The second is, they say, the unworkability of the point, which I address in 48.3. The bottom line is the mere fact that you may agree that a loan shall be an on-demand loan doesn't mean that you intend the day after you've made it to call it in.
Especially not if you know it's going to be used to buy the land on which the hotel is.
Certainly not if you know it's going to buy the land, or if you know that it's going to be invested in the hotel, or at a time when everything is being done on trust and positively and constructively with a view to the whole thing being a success. Yeah. How many loans in the commercial world that businesses depend on that are on demand, but nevertheless are accepted and relied upon and form the basis of a viable business? But moreover, one of the loans that was deployed, or rather, a number of loans that Madame Kwok herself made were essentially either on demand or short-term loans. But they were still contributed and were treated as part of the funding, and she doesn't suggest that those should be excluded from the calculation of what funding had been advanced by each side. Again, I'm going at some speed, I appreciate it.
Can you just, I'm just behind on one thing. Assume in your favour that there was that agreement. What unfair prejudice followed from a failure to abide by that agreement?
Well, it could take several forms.
What was it here in this case? What do you complain of in relation to Madame Kwok's breach of that agreement?
Well, I think what the complaint is, I don't think that there was, as it were, a claim for damages flowing from the failure to fund personnel.
When we've got the dilutions, it's perfectly obvious what you say the unfair prejudice is. But I just don't quite, maybe entirely my fault, but I just don't understand at the minute what it is that flows. Why this matters?
Well, it could matter because if Madame Kwok is not contributing her share.
Well, is that what you allege?
Well, yes, the allegation
unfairly that she didn't contribute her share.
Correct.
And
that she contributed less
Yao
than.
Was unfairly prejudiced. Why? Because Madame Yao contributed more than her share.
Yes, she contributed more. Number one, but also if your 50-50 partner contributes less, that might potentially explain why that person who's running the show feels the need to go and borrow from somebody else who also wants a piece of the action.
But doesn't the judge say that if she had put in that extra 54 million or whatever it was, then the shortfall, which was funded by Cheer Fancy, might not have been needed?
He does, which is exactly
Was that something that was pleaded, or was there evidence about that, or was that just his arithmetic?
I don't know if that was specifically pleaded in that way.
Well, I'll tell you what, if someone could tell us, not immediately, but the paragraphs in the petition which allege the unfair prejudice in this respect.
I will check that.
Thank you.
Yes. So that brings me, subject to any questions you may have in relation to the findings of fact section of the appeal, that brings me to the question of fresh evidence. That application, or that part of the appeal, relates to certain transactions described, as you know, at paragraphs 8.4 to 8.7 of the Statement of Facts and Issues. I don't propose to go to that for present purposes. There's no dispute between the parties as to what the transactions were, and no dispute that they had three related consequences. First, there was the issue by Shaman RVH, I'll call it the hotel company, the issue by the hotel company to Madame Kwok of a 22.03% direct personal shareholding in the company as part of a debt for equity swap agreement. Second, a consequent dilution of Strong Nations shareholding in the hotel company from a majority shareholding of 56% to a minority shareholding of 43.32%, which necessarily entailed a dilution of Crown Treasurer's indirect majority stake in the hotel into an indirect minority stake. And thirdly, flowing from the previous points, a consequent dilution of Madame Yao's indirect stake in the hotel company from 28% to 21.66%. There are disputes as to whether those transactions were commercially justified.
I'll just pause there. Is it also undisputed that Madame Yao was neither consulted nor her consent obtained?
Correct. There's no dispute that she was not consulted and that she was not given the chance to consent. There are disputes as to whether, irrespective of the question of consultation and consent, those transactions were commercially justified and conceptually, therefore, as to whether they were independently unfairly prejudicial to Madame Yao. But Madame Yao does not seek or need to debate the commercial merits of this group of transactions on this appeal. Her case is simply this, that the mere fact that those transactions were entered into without notification to her and without her consent having been sought, notwithstanding their significant dilutive effect on her stake, is relevant to the nature of the relief to be granted by the court in respect of established unfair prejudice. That limited aspect is one that does not require the board on this appeal to descend into the arena of disputed facts. It merely requires an evaluative, arguably a discretionary assessment of whether the admitted dilution of Madame Yao's interest and the failure to notify and consult with her and get her consent are relevant to the relief to be granted by the court.
And so you invite us to exercise our discretion to take this into account if we admit the evidence, or what? What are you inviting us to?
My client challenges the exercise of discretion by the Court of Appeal.
Yes.
I am asking you to. I'm not. In fact, strictly speaking, you're right. I'm not in a sense asking you, and I think you've put your finger on a mistaken way in which I've just described it. The appeal is about restoring the judge's exercise of discretion.
So you invite us to admit the evidence.
But I mean asking you to...
And then in the light of that evidence, to say that's an additional reason for restoring the judge's conclusion?
Exactly.
So we should take it into account.
On the appeal against the Court of Appeal's judgment in reinforcing...
But why do you need it in those circumstances? If you're successful in your criticisms of the Court of Appeal's judgment,
I may not need it, but
if you're not successful in your criticisms of the Court of Appeal's judgment, what good can this do you?
Well, I agree with you. It may be that the fresh evidence ultimately plays a relatively marginal role, but
don't you say? I mean, my lord must be right. That if you succeed on point one, then the Court of Appeal had no basis for interfering with the judge's exercise of his discretion.
Yes.
But if you fail on point one,
yes,
you would say, wouldn't you, well, the Court of Appeal should have allowed in this further evidence because they should have had it before them when they came to exercise their discretion as to the appropriate remedy.
Yes.
And perhaps, in a sense, you will be asking the board to exercise a discretion.
I think it's part of Mr. Chasty's case before the board that even if you were to succeed on your point one, the winding up remedy was still a wrong exercise by the judge of discretion.
Yes.
The Court of Appeal was right to substitute it with a sort of policing remedy.
Yes.
And as I understand it, you say, no, yes, but not if you look at the fresh evidence.
Yeah.
Yes, there is a scenario.
Policing isn't going to work because you've had dilution, happenstance, coincidence, and enemy action, 3 lots of dilution.
Yes. There are a number of scenarios, obviously, that one might end up with, but I can't say that there is no scenario where I may not usefully need the fresh evidence if I'm allowed to rely on it.
But if the question is, do we send it all the way back down to first instance to look at the fresh evidence, or use it ourselves? I understand your submission to be we should use it ourselves.
Yes, because I'm only seeking to rely on it before the board for a limited purpose.
Yeah.
And I appreciate that because of the limited extent to which I'm seeking to rely on it, I can see that for that reason it may play a relatively small part.
In case I've misunderstood you, the limited purpose is effectively to say policing won't do.
Yes.
Because even at the time the judge was writing his judgment, Madame Kwok was engaging in stage 3 of a dilution process.
Yes.
Yeah.
Yes.
There's also the point that the Court of Appeal at page 260 particularly relied on the fact that the one instance of unfair prejudice that they had found had occurred in June 2009.
Yes. It was historic.
It was historic.
And the language, that's when they refer to the sole infraction.
Yeah.
Yes, exactly.
So as it was a long time ago,
Yes.
Illiquidation was too extreme and one could assume that everything would go forward smoothly. But I think you would say this evidence shows that it's not just a historic instance of unfair.
Correct. Yes. I mean, it's almost as if they were trying to beat the judge to it. having finished the trial in November, not long before the judgment, they embarked upon a yet further major dilution exercise, which essentially turned Strong Nation into a minority shareholder, as opposed to, which now means essentially Madame Kwok and Mr. Ng and Chair Fancy control the hotel through their shareholdings in Shayman RVH, because Strong Nation no longer retains 56%, and of course Madame Kwok also is a 50% shareholder in Crown Treasure above Strong Nation.
But if the liquidator is appointed and sells the hotel as a going concern, and gets in one hopes, substantial sum of money, how does the liquidator decide how to divide that up? What is everybody's shareholding to be treated as? Or
well, we need to be careful about the corporate structure. So Shayman, exactly, the liquidator of Crown Treasure, which is two steps removed from the hotel company, would not be able to sell the hotel. All it would be able to do would be to sell its shares in Strong Nation.
Yes. But there's still going to be a pot of money to divide up. But what are the respective interests of the parties?
Well, they'll be represented after payment of any liabilities of Crown Treasure. They will be obviously as per their shareholders. I think the return of capital.
I think what my lady may be getting at is this: a winding up remedy takes the assets of the company being wound up as the liquidator finds them, with all the, if they are, they may not be, adverse consequences on the value of Crown Treasure's shareholding in Strong Nation, which may flow from the dilutions. Whereas a buyout order is often on a hypothetical basis that you ignore the wrongs that have been committed. But as I understand it, you just take that on the nose and live with it.
Yes, I mean that's how the claimant argued her case at trial, for better or for worse, and succeeded.
Well, she did, but she didn't know about the further dilution.
Yeah. Well,
the point is, if she had known about the further dilution, she might have wanted a buyout.
Well, you may well be right. You may well be right. And of course, there could be questions as well as to what actions a liquidator might be able to take in relation to whatever misappropriations or other wrongful dealings may have happened in relation to Strong Nation, or indeed how Strong Nation's rights may have been used in order to allow transactions further down the line to happen.
But are they still 50-50 shareholders in Crown Treasure?
Yes.
Yeah.
Right, but the Crown Treasure's, the value of Crown Treasure's holdings may be affected by dilutions further down.
Have been affected.
Yes, have been.
Well, may have been affected.
Well,
one way
maybe, depending on, well, of course.
One can't ignore the possibly advantageous effect on the underlying hotel business of the transactions which led to the dilutions.
It's theoretically possible.
I mean, we just don't know.
We just don't know. I mean, this is why I'm not in a position to argue that the underlying the third dilution transactions are commercially unjustifiable. I just don't know. But what I do know is that they are major transactions, and my client wasn't consulted, and her consent wasn't sought.
Yeah.
They were just they were imposed on her essentially, and that's it. So therefore, I do wish to preserve the ability to rely on the fresh evidence, but there is a substantial question that is raised by Mr. Chasty as to the admissibility of Madame Yao's appeal in relation to the decision to refuse, the Court of Appeal's decision to refuse the fresh evidence. And that does raise a slightly curious point that I want to address now. Ultimately, we say there's a simple answer to the objection, which is that the Court of Appeal's refusal to admit the fresh evidence was part and parcel of its decision of the 14th of March 2019, by which it allowed Madam Kwok's appeal. If that's right, if that characterization of the refusal to admit the fresh evidence is correct, that has two consequences in my submission. The first consequence relates to the proper construction of the terms of the leave to appeal actually granted by the Court of Appeal. And the second consequence relates to the argument advanced under the 1967 order, the Virgin Islands Appeals Privy Council Order 1967. And that's the argument that the Court of Appeal's refusal to admit the fresh evidence was an interlocutory decision, which could not have been the subject of leave to appeal pursuant to the provision that was actively relied upon in written submissions on the application for leave to appeal from the Court of Appeal. The two aspects are clearly related, but let me address first the question of construction of the terms of the leave granted by the Court of Appeal. You know that the Court of Appeal's decision to refuse to admit the fresh evidence was addressed as part of its judgment, the middle section of the judgment of the 14th of March 2019.
Can I just ask, did they stand over that question to be dealt with in the judgment? Or did the judgment reflect a decision made during the course of the hearing that they would refuse to admit it?
Well, Mr. Chasty gives a little explanation of that in his written case.
Oh, I'm sorry if I've missed it.
And as I understand it, it was essentially dealt with at the same time as the appeal, which took one sitting on the 13th of July 2018. The order resulting from the appeal hearing, which you will find in the key documents bundle, and I'll give you an electronic bundle reference as well in a moment, is tab 16 of the key documents bundle, or electronic bundle page 266. That's the formal certificate of the result of the appeal. That recorded that the appeal was allowed. It did not separately record the dismissal of the fresh evidence application. And there was no separate order made recording such dismissal, as far as I'm aware. Certainly not in the papers.
That may be simply an oversight or a shortfall in the administrative arrangements, but one would expect an application to admit new evidence to be dealt with by an order.
It was certainly dealt with in the judgment. The judgment dismissed it, or the judgment said that the application was refused. I think this is paragraph 94 of the Court of Appeal's judgment, which is electronic bundle 256. So I'm not disputing for a moment that the application was dismissed. I agree with you that it may not be appropriate to read too much into the fact that the only order resulting from the appeal hearing was an order that allowed the appeal, gave directions for the remedy that the Court of Appeal thought was appropriate, but said nothing else about the fresh evidence application.
But it looks as if when everybody went away from the hearing, it was a one-day hearing, and the judgment was about 6 months later, nobody knew whether or not the fresh evidence was going to be admitted or not. It was presumably looked at de beniesi, and when the lead judge says, for reasons stated, well, I would dismiss the application. He's doing it there and then for the first time in his judgment.
Yes.
Yeah.
Yes. And so the...
And that's how it looks on the paper, but
No, you're absolutely right.
Court who would be able to say, well, actually, we all do it to be dismissed. They just say they give the reasons for it in their judgment.
Yes, and moreover, they looked at the application on alternative basis as well. They looked at it on the basis first that they didn't think that it could that it was capable of being made by a respondent. That's a separate point that I'll come on to. But then they also looked at it on the basis of, well, even if a respondent can make such an application, we find on the facts essentially that the application doesn't satisfy the Ladin-Marshall criteria. But I'll come to that in a moment. But I'm simply trying to. I just want to build a picture, the chronology of what happened. So, what we have is basically the application is made. It's dealt with at the appeal hearing in the same sitting. The outcome of the application comes as part and parcel of the judgment in the main appeal. It's all mixed up, as it were. And what you then have is a notice of motion for leave to appeal, which is the electronic bundle, page 7332. And that is the... That's not in the key document bundles. So 7332.
Yes, I've got it.
You will see that Madam Yao sought an order granting leave to appeal to the board against the decision of the Court of Appeal herein delivered on 14th of March 2019. And the part of the Court of Appeal's decision rejecting Madam Yao's application reduced the fresh evidence insofar as contained in the same decision delivered on the 14th of March was not excluded from the notice of motion. The next document then is Madame Yao's written submissions in support of her application for leave to appeal, which is starts at page 3267.
267.
3267.
267.
Yes. And so you will see that especially starting on page 3272. Well, you will see first of all on page 3269 that paragraph 3 of the order is set out. I think I might as well go through those bits even though it relates to the order aspect rather than the terms of the leave itself. But if you look at the order, you will see there are two categories that are potentially relevant for leave to appeal. The first is in 3.1a, appeals that lie as of right from decisions.
Where is the order? You're now looking
this is on page 3269, forgive me. It's extracted in the written submissions.
Yeah.
I think it's quicker to go to that text, which I think is accurate.
Yes, you're running it both ways, as I understand it. You were saying you had an appeal as a
well, yeah,
but if you didn't, you were asking for leave.
That is how it appeared at the time of the notice of motion, but I think it's fair to say that by the time you get to the written submissions, you will see a slight change of tack in the written submissions, which is something that has to be addressed. So you will see that paragraph 3.2 then sets out the alternative basis for leave to appeal, and that's, as it were, substantive leave to appeal, but only where the question in question is one of great general or public importance, or otherwise ought to be submitted to the board.
So you're putting it both ways.
We set out the language for both, but then if you look at paragraph 4 over the page, 3270.
Yeah.
If I can just ask you to read paragraphs 4 to 6, 4 to 7. So I think it's fair to say that the author was saying, well, you, the Court of Appeal, can deal with it simply on the basis of 3.1. There's no need to look at 3.2. But while saying that, the authors went on to describe in some detail what happened in relation to the fresh evidence application. And you see that at paragraphs 15 and 17, which are pages 3272, in a lot of detail, in fact, 3272 to 3274. After giving the detail of the fresh evidence application and the substance of the evidence, paragraph 19 on page 3275, at paragraph 19, recorded that the Court of Appeal had declined to take into account the new evidence as to the above-mentioned transactions, holding in paragraph 93 that the evidence should form the basis of fresh proceedings to be brought by the claimant. And then paragraph 20, the claimant wishes to appeal, etc. So those were the submissions. And then what you have, I'm just showing you the material before I make my submissions, you then have the certificate of the result of the leave application at pages 272 and 273. You can look at, that's the tab 18 of the key documents bundle, if you have that. So page 272 of the electronic bundle, or tab 18 of the key documents bundle. And you can see the interim, the grant of conditional leave, which is later made final, which is that the applicant be hereby granted leave to appeal to Her Majesty in Council against the decision of the Court of Appeal herein, delivered on 14th March, allowing the appeal against the decision of the trial judge. Now, pausing here, Madam Kwok, no doubt, does put emphasis on the words allowing the appeal against the decision of the trial judge. But we say that since the Court of Appeal's refusal to admit the fresh evidence was an integral part of how it disposed of the appeal, those words don't justify the conclusion that the leave granted was intended to exclude the Court of Appeal's decision in relation to the admission of the fresh evidence. And so we say...
I suppose it's a strange irony in this case that, on one view, the only issue of law of anything remotely like general importance in this case is the Court of Appeal's decision that a respondent can't admit fresh evidence.
Indeed, that is a submission that comes in a moment, but which you've preempted.
Just on this allowing, if they had decided that although they had only found the one or two breaches of the agreement as they interpreted the Court of Appeal, if they had overturned various findings of fact, but they had concluded that the appointment of a liquidator was still justified, I think they would have dismissed the appeal, wouldn't they?
Yes, they could have dismissed the appeal, yes.
So the question of whether they allow or dismiss the appeal does turn on what they decide to do about the remedy. And it's that to which the fresh evidence went, isn't it?
Yes. It is quite apart from the fact that physically, as it were, the decision about whether or not to admit the fresh evidence is part of the same judgment, right in the middle of the judgment that is the judgment on the main appeal. Undoubtedly, in my submission, there were circumstances, perhaps not the one that actually happened, because the Court of Appeal refused the application, but in order to test how Section 3.1a should be applied, in a case where there is an appeal that has with it an inseparable companion, which is an application to adduce fresh evidence. Imagine for a moment that the Court of Appeal had allowed the fresh evidence to be admitted and had relied on it in some way, either to decide against Madame Kwok or to decide in her favour. Imagine for a moment that the Court of Appeal allowed the fresh evidence in, but decided that the appeal should be dismissed. The other side would have wanted to come to the board as of right, and they would have said, well, we are entitled to come before you as of right. The Court of Appeal allowed the fresh evidence in and took it into account when dismissing our appeal. We don't agree with them. And obviously, we were going to appeal that at the same time. Now, is it to be suggested in that context that there needs to be a separate test under Section 3.2 of general public importance to be applied to that element of the appeal decision that allowed the fresh evidence in and relied on it in support of the outcome of the appeal? It's very difficult to see why that should be. And on the other hand, if the appeal, if for example, the appeal had been allowed, but with the fresh evidence in, that the other side wanted to challenge, does it therefore follow from that whilst we would have the ability to appeal as of right, they would have to make a separate application for leave to appeal under 3.2 and 3.2 alone? That would be very odd as well. And what all of this points to, in my respectful submission, is a very simple rule that is a rule of common sense. If an application for fresh evidence to be adduced on appeal is made in conjunction with an appeal and dealt with as part of the appeal, one ought to treat the decision in relation to whether or not the fresh evidence should be admitted or rejected as being part and parcel of the final decision. It should not, in my respectful submission, be treated as some island of its own, which, if it were to be appealed against, would have necessarily to satisfy independently and separately the Section 3.2 test.
Well,
if it were other...
You don't need to go that far, do you? You could simply say that, it would be, depending upon the circumstances, it would be appropriate.
Well, yes, I suppose that would be...
It doesn't have to be an absolute...
I don't have to make the bar too high for myself. But obviously, if one were to say it might be appropriate in some circumstances, but it might not be, then one then has... I suppose as a rule maker, one might then think, well, what would be the circumstances that are appropriate and what would be the ones that are not? And what I'm suggesting, one would think as a matter of common sense, where the fresh evidence is part and parcel of the points being argued on appeal, whether for example, the fresh evidence goes to an important point as to the form of relief, which is undoubtedly under appeal, and rightly so under Section 3.1a, it would be artificial and would lead to an undesirable dislocation between the decision at Court of Appeal level and the decision at board level. In fact, if need be, I rely on this very point itself as justifying leave to appeal under 3.2 if I had to go that far. But I would suggest I don't actually need to go that far.
It can't depend on whether the Court of Appeal chooses to deal with it as they did deal with it, or whether they say at the outset of the hearing, right, you've got 15 minutes each on the fresh evidence and then we'll make our decision and then move to the substance and give a little 2-paragraph extempore judgment. I mean, that it can't... this question can't turn on that kind of case management.
I agree with you, it can't be a pure timing point. It has to be a substantive point as to whether the fresh evidence in question is intimately connected with the issues on the appeal, which themselves, when decided either way, would be appealable as of right. And if it is intimately connected with those issues, in my respectful submission, it should be treated as being, the decision about that question should be treated as being part and parcel of the final decision that's covered by 3.1a, rather than having to be made the subject of a separate application with its own standard under 3.2. Because otherwise it would, whilst one can imagine some cases where a fresh evidence application might give rise to some point of general public importance, one imagines that in the greater run of cases it won't, which then would mean that whilst the Court of Appeal would have the luxury of deciding whether or not to take the evidence into account, when it comes to an appeal from the Court of Appeal to the board would be entirely in the hands of what the Court of Appeal decided. If it allowed the fresh evidence to be in, then the board is effectively stuck with it, and the party who complains about the admission of the evidence is not able to argue against it. But if the Court of Appeal decides in favour of the rejection of the evidence, then it's the other way around. And you end up in this bizarre situation, therefore, where what the Court of Appeal decided and the entire body of evidence that it was theoretically available to it to consider is not the same body of evidence as may be available at the Privy Council level. And that would be very odd. That would be very odd. I hope, therefore, that I don't need to ask you to give substantive leave, if I needed it under 3.2, on account of the 2 points of general public importance that we've just been discussing. One about the operation of Section 3.1 itself and 3.2, and the second, which I now turn to, which is whether there is any principle of law that a respondent to an appeal cannot rely on fresh evidence. Now, Madam Kwok, in her written case, has suggested the Court of Appeal did not conclude that a respondent could not apply to admit fresh evidence. And they say that, and you will see that at electronic bundle page 7752. She says all that the Court of Appeal said was that it would be rather strange, but it didn't actually conclude firmly that this was not a course open to a respondent to an appeal. We disagree. If you look at paragraph 92 of the Court of Appeal's judgment, which is electronic bundle page 254, you will see that Justice of Appeal Gonsalves stated that he was of the opinion that the application was misconceived after, this is 4 lines from the bottom of page 254. He was of the opinion that the application was misconceived after observing that Madame Yao had been unable to cite any authority to support the proposition that a respondent can in principle make an application to adduce fresh evidence on appeal. Furthermore, he went on to state that the provision of a further ground for supporting a decision in the court below is not a proper basis for the exercise of this very reserved jurisdiction, and in my opinion does not satisfy Guideline 2. Guideline 2, you will recall, is the one that requires that the fresh evidence, if admitted, would probably have an important, even if not decisive, influence on the result of the case. Now, this particular reasoning of the Court of Appeal is in the nature of an objection of principle to the legitimacy of an application by a respondent to rely on fresh evidence on appeal to support the decision of the court below. And so we say that this is a finding of principle, that axiomatically a respondent is not capable or entitled to rely on fresh evidence.
And you see the first line of 93 makes that reason.
And indeed, I hadn't got that point, but you're quite right. That reinforces the analysis of 92. Now, I don't need to deal with that point in detail. I have given 7 reasons in my written case as to why this cannot be right Given the time that I have, I think I can simply rest on.
You've only got about 3 minutes.
Yes.
That clock, incidentally, is slightly slow.
So I may have a couple more minutes. Now, that brings me to the final topic, which is what we say was, in any event, the flawed exercise of discretion by the Court of Appeal in the light of or rather the question of the relevance of the fresh evidence to the exercise of discretion. I think, in fact, I can skip over that because I've told you, I've made my point already about that. So I deal with the question of the overturning of the judge's underlying order to wind up. There's first a pleading point taken by Madam Kwok, which was also taken before the Court of Appeal. We say that was rightly rejected on two grounds. Summarise paragraph 62 of the Court of Appeal's judgment, and we say, in short, that the Court of Appeal was right for the reasons it gave, but we asked the Board to bear in mind two additional considerations. First, the approach of the Court of Appeal to the pleading point was entirely consistent with and reinforced by the Board's observations in the Ming Siu Hung case and in Lau and Chu, quoted at paragraph 64.3 of our written case. Again, I don't need to repeat that.
But a page number would be nice.
So page number 63.4 is pages 7720 to 7721. I think I can. I think there's a lot made in my learned friend's submission that Madame Yao not only had ever pleaded or submitted that the liquidation order was justified on the sole ground that she had not been consulted about the loan agreement 2045. I will just give you some references to the transcript of Mr. Fisher's oral closing that show that actually he put the case rather more broadly. I won't have time to take you to it, but I will give you the references. If you look at his submissions on pages 7039 to 7045, as well as page 7050, lines 17 to 22.
Thank you.
I then come to the actual exercise of discretion as to the remedy by the Court of Appeal. Again, I've dealt with the points in some detail.
We're going to have to take it from your written.
Yes, I think.
Unless there's some brand new point that simply isn't there that you want to press upon us in your remaining minus 1 minute.
Yes. The one point I want to ask you to bear in mind is this. The Court of Appeal ordered a remedy around the limited agreement that they found concerning transactions that would introduce a third-party investor. And they added a qualification, which was that consent should not be unreasonably withheld. Now, obviously, if you find, I just asked you to bear in mind that if you find in Madame Yao's favour that the agreement was broader, more wide-ranging, I can see that it might still be suggested, well, why can't a similar remedy fashioned by the Court of Appeal also apply to the wider type arrangement, and also with the proviso? But that would not work or be appropriate in my submission, because there's no suggestion and there's no evidence that the agreement was subject to a proviso that consent should not be unreasonably withheld. There was no argument articulated on the basis of, for example, some implied term. There was no evidence that was explored at trial to that effect. The agreement, as alleged, was that there should be no major transactions without consent. And that's an important aspect, which goes, in fact, not only to the relief that conceptually might be granted, but it also goes to what we say is the very close analogy between the case where there is an agreement for participation in management and a case where there is an agreement which we say was found by the judge and couldn't have been overturned by the Court of Appeal, an agreement that there will be that there must be consultation and consent must be sought without any proviso or escape clause through any concept of reasonableness in relation to all major transactions or decisions. That makes that agreement very close to an agreement in relation to participation.
Well, even the slow clock says you've run out of time.
My Lord, I'm grateful. Unless you have any further questions, I will sit down.
Thank you very much.
Thank you.
Mr. Chasty.
My Lord, just to get into some of the broad points in the few minutes that I've got before we take the break, and then I'll come back to some of the points in detail. And this is going essentially to ground three, first of all. A point to stress, which hasn't been stressed at all as yet, is that Madame Yao chose, we say deliberately, but she chose to ask as her primary remedy for an extremely unusual order. She sought an order that Madame Kwok be forced to sell to her, not the usual order that one might seek in an unfair prejudice petition. And she did so in particularly unusual circumstances where it was clear that she had not participated in management over very many years. She'd had no role to play. All the work had been done by Madame Kwok, from the foundations all the way through to the hotel being the success that it is. But she chose nonetheless to ask for that kind of share buyout, rather than to ask that based on her allegations of unfair prejudice, she should be bought out. And we contended at several times that that was a deliberate tactical decision, partly, I think, because of a point that was raised earlier during the debate, which is that Madame Kwok was reserving her position in the sense that she wanted to buy, no doubt, Madame Yao wanted to buy, no doubt, Madame Kwok at what she thought might be a reduced value because of these alleged, although it was never quite clear what was being said, wrongdoings in respect of share dilution, with a view to acquiring control of the company, and then, no doubt, trying to take some steps to unravel or undo those transactions, and thereby gain the advantage, having bought at a lower price, as she should see it. She didn't choose to ask that she be bought out, and it also became very evident that she was embarking on that course of conduct, even though she had no idea whether she had the funds to ever meet a share purchase order that might have been made.
Was it ever suggested on your side that Madame Kwok should buy out Madame Yao in the event that the Court of Appeal or the judge was against you?
The way that it came about was this. The short answer is no, but the circumstances in which I answer that is important. Madame Yao made it clear throughout the whole of the trial that she had no desire to be bought out. Her position essentially was she gets the company or nobody gets the company, in the sense that she made it absolutely clear she wanted the order that she wanted as a primary remedy, but if not that, then liquidation. At no stage did she suggest that if what I say is an extremely unusual order was refused, then she would like to be bought out. What happened was, and I can take you to the page references, perhaps I should do that in the few minutes I've got.
Well, before you do, the fact that she wasn't interested doesn't stop the court, whichever court it is, from deciding that that's the appropriate order to make.
Exactly, but that's not what the judge did, even though he said that
he wasn't asked to by either side.
Well, can I show you the passages, and then you'll see the way in which the conversation took place. So just to pick up on a few different places. First of all, he said, I'll just give you this reference just to put the marker down. He said at the transcript at 7139, the judge said to me during the course of argument, he said, let me say this, that I can say that I felt that a winding order is unlikely to be proportionate in a case like this. I said, I'm grateful for that. Let me move on, therefore, to unfair prejudice. That's a point that he made quite early on.
This was the trial judge?
That's the trial judge. Now, Mr. Fisher, at 6983, was asked by the judge whether there was any middle ground. And he said, there's a range of remedies that your lordship can consider. Your lordship can order that the defendant buys the claimant shares. Your lordship can give directions as to future conduct of the company, future management. Your lordship can order these things to be done, things done to be undone. Your lordship has a range of remedies available.
Where is that?
That's, I believe, at 6983 of the transcript. The judge picked that up again later at 7169. 7169. And he said at the bottom of the page, what I plan to do in the event, it's depending on how the arguments are going and the various possibilities that present themselves to the court. If I think there's necessity to consider another order, I'll give you an opportunity to comment on it. So we were left believing that what the judge was considering was certainly no winding up order, although I'll come back to one other point in a second. No winding up order. He was considering whether or not a reversed share purchase order might be appropriate, but he said, if I'm going to think about doing that, I'll come back and let you have comments on it. What then seemed to have happened is quite strange, because it seems as if the judge may have been unsure what it was that a liquidation order meant. If you go, please, to 7309, I think. And indeed, I think just the previous page. Mr. Fisher was talking to the trial judge about a liquidation order, and he was explaining that what they wanted as the alternative was to put a liquidator in charge so that the liquidator could sell the shares. And then there'll be a bidding war, and whoever pays the highest price will get the shares. And the judge said that would be one way for getting money out. Yes, ensure that the best price was paid, because it would be, as it were, open competition between all interested parties. Judge said, I must confess I was thinking more of the holding company, the company in Germain. I was thinking at the back of my mind more so than the parent company. Yes, when I made my comments pertaining to, my lord, yes, that's what I really was thinking. I'm sorry, I'll have to look at that again. So the judge, having said that he wasn't going to make a winding up order, or at least that's not what he thought would be appropriate, the debate seems to be that he'll bring us back to argue if he's thinking about making my client buy out Madame Yao, then seems to have realised that he may have misunderstood what a liquidation order actually meant. But if I may say, puts his desires quite to the forefront when he says that's one way of getting the money out. But then if you go to his judgment...
Just before we do it, Mr. Fisher was for the petitioner.
Yes.
Is this the last speech going on?
Yes.
So he's in reply?
That's in reply.
Thank you.
So, and it's pretty well the last few minutes.
Okay.
And there was no further conversation about that. So the petitioner chose, we say, to give the judge a very stark choice. We say, asking for a share buyout in the petitioner's favour, which we argued strongly had no prospect of success realistically. A very unusual order to make it that way round. And we referred to lots of authority on the reasons why it's rare, especially when you have Madame Kwok, who is the person who has for all the years got the expertise and experience in running the shop, running the business, and Madame Yao hadn't even visited the hotel in 11 years. That's a point perhaps to stress when we come to any kind of arguments about quasi-partnership or something close to a relationship.
She's not suggesting that if she buys out the shares, she's suddenly going to be managing the hotel.
Well, she's going to be fully controlling the holding company, and she'll then have to put a whole new team of management in place.
Right.
Well, because Madame Kwok has been running the shop until then. She is the general manager. She is in the day-to-day, 24-hour, 7-day-a-week control, and has been.
Well, see that she might have voted with her feet, having been bought out, but that doesn't necessarily follow.
Well, it doesn't necessarily follow, but I think it's probably a reasonable assumption based on the state of play of these individuals after this length of litigation. And so,
Mr. Chater, you didn't in your did you in your appeal to the Court of Appeal include as a ground of appeal that the judge had suddenly gone for a winding up without having told you he wasn't going to do so, without giving you any opportunity to put in submissions?
I didn't put it on that basis, no. I didn't. I put it on the firm basis that it's a completely irrational and unprincipled order to make.
But didn't the judge want to achieve two things? First, a clean break between the parties, given what he had seen of them in the witness box, and also that the company, the hotel, should continue as a going concern, but sold so that the parties could get their money out.
If his motivation was simply the parties can get their money out, we would respectfully say that's quite unprecedented as a justification in itself for simply putting the company into liquidation. There need to be some grounds beforehand to get to that position. Otherwise,
Mr. Chasty, I mean, getting your money out is a standard remedy for unfair prejudice.
yes.
And there are two ways in which Madame Yao could get her money out. One was by liquidation, the route chosen by the judge. The other was by your client buying her out.
Yes. But
It doesn't appear you ever put the second alternative to the court, despite this discussion we see towards the end of the trial.
well,
No doubt because actually what you wanted was at most the sort of order that the Court of Appeal made.
well, I wanted the dismissal of the petition.
Well, but failing that.
Yes, because the petitioner had made it absolutely clear what her.
What I don't understand is if the judge thought, as my lady puts it, there should be a clean break and the petitioner should be able to get her money out, and that making your client buy her, or rather allowing Madame Yao to buy your client's shares was going too far. I mean, what is wrong with a liquidation as a means of achieving that in the absence of someone saying, well, Madame Kwok will buy Madame Yao's share?
Well, what he didn't do is explain why buying Madame Yao out was disproportionate. He simply said it.
No, but that would, no. I think it was the other way around. He said didn't he say it would be disproportionate for
Me to
have to sell your shares?
Yes.
Yes, no, he was never asked to consider, the possibility of your client buying Madame Yao's share.
No, he wasn't, because I didn't bring a cross petition.
No.
As far as I was,
a matter of a cross petition, it would have just been a discussion as to what the appropriate rate.
But as far as my client is concerned, she'd done absolutely nothing wrong. And I look at.
I know, Mr. Chasey, of course that's right, but you lost on that before the judge, and you lost in the Court of Appeal. So the question is, what is the appropriate remedy?
Quite, and the judge said.
I'm quite sure the point you're making.
Well, the judge said, I'll bring you back if I'm thinking of the alternative remedy. He didn't ask for any submissions at all at that stage.
Well, that's right, but my Lord has asked you, that wasn't a ground of appeal to the Court of Appeal.
No, it wasn't, but I'm perfectly entitled to make the point that he made no explanation as to why he felt my client having to sell was disproportionate, nor did he explain in his reasons why a liquidation was nonetheless fair and
Well, you were going to take us to the judgment.
That's paragraphs 104 and 105 of the judgment. I see that
I think we've probably got to
a stage.
a point where you can regroup.
Certainly.
Mr. Chasey, they will resume at 2 o'clock.